Good morning, Doctor and class. Today we will be presenting on tutorial question number 9, which asks us to elaborate on 5 main objections expressed by developed nations against the provisions of Part 11 of the Law of the Sea Convention 1982 relating to the deep seabed. In addition, we will be discussing to what extent these objections have been addressed by the 1994 Agreement on the implementation of Part 11 of the Law of the Sea Convention 1994. Before I begin the presentation, I would like to start with outlining our agenda so that you are aware of what we will be covering today. First, I will address the history of Part 11 of the Law of the Sea Convention, the development of the New York Agreement, as well as the relationship between the two instruments. Second, we will both outline the primary objections to Part 11 of the Convention, which led to informal discussions for the drafting of the New York Agreement. Third, we will assess whether the objections have been addressed within the document. This will be done both through the discussion on the objections and throughout the presentation. Finally, we will finish with our conclusions. I will now turn to the history of Part 11 of the Law of the Sea Convention and the development of the New York Agreement. Part 11 of the Law of the Sea Convention refers to the deep seabed. It consists of Articles 133 to 191 and is broken into 5 sections: general provisions, principles governing the area, development of resources of the area, the authority, and the settlement of disputes and advisory opinions. However, for the United States of America, Part 11 of the Law of the Sea Convention contained provisions that were deemed unacceptable in its interests, and it wasn't until after the New York Agreement did the United States give considerable attention to its provisions. At the time of conclusion of the Law of the Sea Convention in 1982, President Reagan chose not to sign the treaty. Rather, his administration consistently objected to Part 11 of the Convention on the basis that its provisions did not reflect the economic needs of the United States. Rather, they accepted all other provisions within the Convention as customary international law except for Part 11. Instead, the United States chose to implement domestic measures distinct from those expressed within this part. Many Western European nations followed suit from the United States and implemented their own domestic regulations pertaining to the deep seabed, and the objections to the treaty were sidelined until 1990. It wasn't until the Clinton administration pushed for a supplementary agreement, the New York Agreement of 1994, to replace the provisions of Part 11 of the Law of the Sea Convention, at the point which the United States began to reconsider the original provisions. A series of informal sessions were convened by the United Nations Secretary-General, commencing in 1991, to discuss this. The objective of the consultations was to achieve wider participation in the Convention from the major industrialized states in order to reach the goal of universality. The agreement was adopted by Resolution 48263 on July 1994 by the United Nations General Assembly in New York, hence its title, the New York Agreement of 1994. The agreement itself contains 10 operative provisions and annexes, but its substance is largely procedural in nature compared to the Law of the Sea Convention. In terms of its recognition and status amongst states, it is ratified by 150 parties. 3 more states have signed but not ratified the agreement. However, the question remains, is this reflective of customary international law? Is there significant state practice and opinio juris? Despite not all states ratifying the convention, it is widely represented by states from the North Atlantic Treaty Organization, the Organization for Economic Cooperation and Development, Russia, China, and the European Community. This demonstrates that the convention itself is touching many corners of the globe and is not siloing itself to one continent over another. In terms of the relationship between the Convention of the Law of the Sea, Part 11, and the New York Agreement of 1994, it is both complementary and contradictory. Article 2 of the agreement outlines that the provisions of this agreement and Part 11 shall be interpreted and applied together as a single instrument. In the event of any inconsistency between this agreement and Part 11, the provisions of this agreement shall prevail. However, as will be discussed throughout this presentation, Certain contentious points remain within the original text and have not been substantially modified by the agreement. Accordingly, certain contradictions arise. For the purposes of today's presentation, we will be discussing 5 key objections. First, in relation to a state's contributions to the authority. Second, the operation of the res communis principle as a general principle of the law of the sea in respect of deep seabed mining. Third, the transfer of technology. Fourth, the council. And finally, the funding of the enterprise. Before outlining each of the objections in turn, I thought it best to make some general comments about whether or not the objections have been addressed, so that this remains in the forefront of our viewers' minds. Firstly, it is our opinion that the agreement still retains a collectivist view despite its amendments. In addition, the original regulatory bodies remain the International Seabed Authority, the Assembly, Council, Commissions, and the Enterprise. Certain provisions within the original agreement and the agreement remain vague. Section 8, for instance, states payment is to be fair both to the contractor and to the authority, but fairness retains a subjective standard, and this is present in other articles throughout the agreement. In addition, the authority is granted powers that remain unconstricted by the amendments, and clarification was needed to occur by advisory opinion in relation to a state's liability for private entities carrying out seabed mining. This was through the International Tribunal for the Law of the Sea's advisory opinion, Obligations of States Sponsoring Persons and Entities with respect to activities in the area from 2011. The first objection that I'll be addressing in relation to the Law of the Sea Convention is a state's contributions. Under the original convention, Article 171 outlines the funds of the authority. This states that the funds of the authority shall include those assessed contributions made by members of the authority in accordance with Article 160, paragraph 2e, and voluntary contributions made by members or other entities. Section 160, subsection 2, outlines that the powers and functions of the Assembly shall be to assess the contributions of members to the administrative budget of the authority in accordance with an agreed scale of assessment based upon the scale used for the regular budget of the United Nations, until the authority shall have sufficient income for other sources to meet its administrative expenses. The agreement now outlines in Section 1 that in order to minimise costs to state parties, all organs and subsidiary bodies to be established under the Convention and this agreement shall be cost-effective. This principle shall also apply to the frequency, duration, and scheduling of meetings. So the overarching principle applicable to the agreement is cost-effectiveness. However, Section 7 retains the phrase funds necessary to cover the administrative expenses of the authority, with no clarification as to what necessary means. Section 9, however, establishes the Finance Committee, which is represented by the 5 largest financial contributors to the administrative budget. This merely continues the allowance of certain states having a strong influence on the authority compared to others. The original concerns were there was a risk of monopolising the enterprise as the operational body of the authority, and at what point, if an agreed scale of assessment is used based on the scale used for the regular budget of the United Nations, is it deemed that the authority shall have sufficient income? Is this a subjective standard? The basis of cost-effectiveness does not adequately address this point, and on this basis, it is my opinion that the original objection has only partially been addressed through the implementation of the Finance Committee as a buffer committee. The second objection that I'll be addressing is the principle of res communis. This is outlined within Articles 136 and 137 of the Convention on the Law of the Sea. Article 136 outlines the general principle that the area and its resources are the common heritage of mankind. This is further elaborated on in Article 137, which states that no state shall claim or exercise sovereignty or sovereign rights over any part of the area or its resources, nor shall any state or natural judicial person appropriate any part thereof. In essence, this provision is outlining that no state can have a sovereign claim over the natural resources that lay within the deep seabed. The former provisions, contained within the United Nations Convention of the Law of the Sea, allow for unclaimed resources to be subject to international control. That is, that any country may exercise sovereignty over these particular parts, should there be an absence of provisions that indicate otherwise. This results in developing states having the capacity to object to industrialized states' claims over resources. In essence, it strips major players of their veto powers in this respect. In terms of the New York Agreement, within various sections, namely sections 2 and 6, provisions in relation to contractors have been implemented to allow for monopolization over certain areas. This ultimately rests on the position of consent. However, with industrialized states now holding power over the authority and seats on the Council through the New York Agreement, this allows industrialized states to have a larger bargaining power in the allocation of those resources that lay within the deep sea bed. On this basis, it cannot be said that this objection has adequately been addressed by the agreement as well. The final objection that I will be addressing for this presentation is in relation to the transfer of technology. Article 144 of the Convention of the Law of the Sea imposes compulsory transfer of technology. As a result, many states raised concerns following its drafting in relation to security protection of their sovereign interests. Article 144 outlines that authority shall take measures in accordance with this convention to acquire technology and scientific knowledge relating to activities in the area, and to promote and encourage the transfer of this technology and scientific knowledge to developing states, so that all state parties benefit therefrom. In essence, the purpose of Article 144 of the Law of the Sea Convention is to ensure that the deep seabed remains a shared resource between developed and developing nations. However, many states raise concern in relation to the compulsory transfer of technology, and thus, to curb these objections, the New York Agreement outlined additional requirements within Section 5(1)(b). Most notably, though, with this section, is that it begins with, in addition to the provisions of Article 144 of the Convention, transfer of technology for the purposes of Part 11 shall be governed by the principles. This demonstrates that the original text contained within Article 144 remains, and what has been added is in relation, most notably, to subsection B, that the enterprise or developing states, if they are unable to obtain deep seabed mining technology, may seek the authority to request the assistance of developed states to cooperate in the acquisition of technology and scientific knowledge relating to the deep seabed. This demonstrates that, in essence, industrialized states and private miners are responsible for cooperation with developing states. The effect of this is that Article 144 remains operative and vague in its operation. The phrase, for example, the advancement of technology, means that the authority's request for cooperation from developed states is founded on quite an expansive principle. As a result, Section 5(1)(b) does not really add to the subject matter that was already contained within Article 144, and on this basis the objection has not been adequately addressed by the New York Agreement.